Saw a case that came out this week from the Appellate Division, Second Department. It's a personal injury case. And you saw something you don't really see a lot of in this state, which is a plaintiff, an injured person, moving for summary judgment. That would be essentially establishing a cause of action, establishing liability on papers with regard to a serious injury. As you may or may not know, in New York, in a bodily injury case and other no-fault cases, you have to meet what's called the threshold. Uh, and one of the threshold categories you sometimes see plaintiffs move for to seek judgment on is they call it 90/180. What that means is that you, as a plaintiff, were not able to engage in your regular customary activities for any 90 of the first 6 months, 180 days following the motor vehicle accident. But generally, that's usually met by someone not going back to work. That's generally the case law and in the practice of law, how that is met. So if one of these cases goes to trial, one of the things you would show is that you didn't go to work for 3, 4, 5 months following the accident. And then you would have medical evidence showing that you suffered a medically impaired, some type of disability, although non-permanent. So for instance, you would have a neck or back injury, which prevents you from sitting or from walking. And let's say your job is, landscaper, factory worker, cashier, one of those positions. You just can't work. You just can't stand, right? And you're out of work for 3, 4, 5 months, and you have medical records to substantiate that you just can't go back to work and that you do have this type of injury. Usually that would meet that threshold. So what a good plaintiff attorney does is they say, okay, well, why don't we try to get this done on motion? Because if you can win that argument on motion, then when you go to trial, the question isn't whether or not you suffered a serious injury, but the question is to the jury, how much money do you give this person for past pain and suffering, future pain and suffering, medical expenses, wages, right? So in this particular case, what happened, and why it's important, is that they moved for summary judgment, saying that the injured person, and the facts aren't clear, but you could pretty much assume they didn't go back to work for a period of anywhere 3 to 6 months following the accident. And then the plaintiff produced an affidavit from a doctor, from medical records involving treatment that occurred 1 year post-accident, stating that the person was disabled and couldn't go back to work. And they got summary judgment out of the lower court. The defendant, the insurance represented by an attorney paid for by the insurance company, appealed it. What the appellate division said, which is very noteworthy, is that, as you know, one of the things they said is that you can't move for summary judgment on the issue of whether or not you have a permanent or serious injury or threshold injury until full discovery has occurred. So in this particular case, the defendant didn't perform a medical examination, so it was premature. But really what's important, and really something you need to be aware of, is that the appellate division said, in any event, you didn't make a showing that you sustained this serious injury on papers because there was no evidence contemporaneous, that is around the time of the accident, showing that you had medical treatment and that you did suffer these injuries and that your inability to perform services work for the first 90, 180 days is related to an injury or a condition that's contemporaneous from the accident. The lesson to be learned, though, from this legal speak is this: if you're in an accident, you need to get treatment immediately. Immediately means that day, the next day, the date thereafter, very soon, right? You need to continue with the treatment, 2 to 3 times a week for your physical therapy sessions. And you got to do that for the first 6 to 9 months, and if you're not able to work, you then will be in the position that this plaintiff, after the second department reversed, was not. The position you'll be in is you had an accident. Presumably you're not at fault. You didn't work after the accident. And you had treatment showing that the doctor said you couldn't work, and you have a neck and back injury that's causally related to the accident. And that's a very strong case. That would, in many instances, meet that threshold, and that would allow the plaintiff under certain circumstances to successfully move for summary judgment and allow you to increase your chance of recovery. Because if that motion is granted pre-trial, like I said before, you've established as a matter of law that you're injured and that your injury is serious. And then essentially, if the case has to be tried, the jury again is asked generally two, 3, or 4. The question they're asked is not whether you suffered a serious injury. They're asked, how much do you give this person for past pain and suffering? From the date of the accident to the date of the verdict. How much do you give this person for future pain and suffering from the date of the verdict until the end of this person's life? What do you estimate is this person's lifespan? And if there's a wage claim, how much in lost wages did this person sustain from the date of the accident up until the date of the verdict? How much in lost wages did this person sustain from the date of the verdict up until the rest of his life? So, just a little practice tip. You see cases that come out, and if I'm giving these lectures or these speeches here, just something I want to share. Thank you.